with this, hopefully people see that there is remedy there if you know what you're doing.
Yeah, definitely.
If you follow the evidence, and then they must provide a reasoned decision, we can move into criminal prosecutions with them.
Music to my ears. Right.
Yeah.
I'm good. Right. This is going to be a reasonable video in length, I would imagine. What everybody's talking about at the moment, the Bristow Sutor Leighton case.
And, and there's a lot going around about liability orders. So what I think we should do is really start at the beginning,
Always.
before the Bristow Sutor thing,
Yeah.
and then give background, which we're starting to do, so that people actually understand the difference between legislation, law, and all of that. And why this judgment is so important, as well as the what's the other judgment? The Woolwich Woolcock judgment as well.
Right. Okay.
Directly relates to the council tax. Then what we'll do is go through the legislation so that people can actually understand, because this shows you how legislation's interpreted by the courts.
Right.
That is what creates law. It's not the legislation that creates law. I really want to try and drum that into people so that they get to understand this thing about authority.
Yeah. Okay. Well, that's not just the general public, though, is it?
It's no. Well, it's important for the general public to actually understand what's going on, and so that we can start to address this with the legal professionals and the courts and the judges, that the rule of law actually is
Yeah.
what prevails.
Yeah. That's what I meant. Yeah.
Parliament's never had authority to create law. It's always been created in the courts.
Yeah.
And we'll go through the background again, and this will be much more extensively covered in the constitutional course once that's together.
Brilliant.
So just basically, where does one start? People talk about English constitution. England itself, when was that formed? It was first known as England when the three kingdoms merged. And what they did then, they took all the law in common between the three kingdoms, which became the law in common. And so really England itself was sort of established pre-Norman invasion 1066, where the law of conquest prevailed. What we do know is Magna Carta 1215, and what is important about Magna Carta 1215 is the monarch bound himself to the rule of law. How do we know this? He subjected himself to the barons.
Right.
So between themselves, they put the rule of law. They created the law.
Right.
It used to be the law of conquest. Then the monarch subjected himself to the barons as the first step. And then in the confirmation of the charters, 1297, this is important, it's current statute law. Okay. And it legislatively affirms, i.e., Parliament itself admits in there that the law of the land is the common law, as it was expressed in Magna Carta 1297 at the time, which was the Great Charter. And therein, the monarch reaffirmed, binding himself plus his successors to be subject to the common law, the law of the land, as it was expressed at the time.
Okay.
Carta 1297. So already we have, pre-1300s that the royal, what evolved into royal prerogative, or is called royal prerogative, is subject to the law of the land, and that was affirmed in the Boris Johnson judgment, the prorogation judgment in 2019. So there can be no dispute that the monarch governance is subject to the rule of law.
Mm-hmm. Okay.
Now, The earliest I can find is 1414 for a claim that the commons needed to assent to money bills to raise money for the king. And there's other sources which say it was by the mid-1530s that both assent was needed from the House of Lords as well as the House of Commons as it was then. And people need to understand that it's not anything like the House of Commons today, what was then. So when people say Parliament was started in 1275 or 1300, it was a very different Parliament. It's nothing like what they're talking about today.
Right.
So, but basically by the mid-1530s, it seems relatively undisputed that both assent was needed from both the Commons as well as the Lords for statute law to be enacted by the monarch, i.e. royal prerogative. It still needed the signature of the monarch or the authorization of the monarch. We've been through before about the 1609 James I speech to Parliament, where he was pushing the divine right of kings because he still didn't get it. He wasn't prepared to subject his monarchy to anybody else. And in 1610, in the case of proclamations, because the Commons rebelled, they refused to authorize money for the king. And so the case of proclamations with Coke in 1610 affirmed, with agreement of, in essence, the Privy Council, all of the councils of the king at the time, that there are three sources of law: common law, statutory law, and customs, and that the king's proclamation is none of them. So again, if we look, equity prevails, which came in 1615, over the rules of the common law. A proclamation could be under any color of law, declaring or enacting or anything, the law. But you had here already the clear separation of powers evolving. So the Parliament already had gained a lot of legislative rights from the royal prerogative, i.e. the monarchy gave away or granted the rights to legislate prior to the Bill of Rights in 1688. But the Bill of Rights 1688 sums up the lessons learned and expresses governance. And the reason it's lawful is quite simply due to the words, nothing can be done to the prejudice of the people in any of the said premises. So long as nobody is causing another harm, it's perfectly lawful whatever you do. So the Bill of Rights expressed the separation of powers, okay? And the rule of law being supreme constitutional principle, because everywhere it talks about in accordance with law. So what happened was it was formalized and expressed that Parliament must be agreed by acts and statutes must be agreed by Parliament. That today we call primary legislation is created by Parliament. And as he who creates has authority to uncreate. So Parliament can unenact or repeal or modify anything that it's done. However, like we said before, the Bill of Rights is not only an act of Parliament, it's a written contract of governance. Perfectly lawful. So in Article 1 and 2, it affirms that the executive body, okay, and you need to separate royal prerogative from the monarch, the Parliament, the legislature, and the judiciary. It's not disputed that all of those branches used to fall under the in effect, the divine rights of kings, the royal prerogative or regal authority.
Mm.
So that is the source of governance. However, Articles 1 and 2, the royal prerogative, the monarch has said, okay, Parliament, you have the right to legislate, and I will do what you tell me. In regards governance only, the executive. Okay. And then the executive creates secondary legislation, and that goes back to there are the 1610 judgment of, in the case of proclamations, it actually wasn't a judgment, it was an agreement in the notes of Coke. It wasn't a court case. So where it says there are three sources of law: statute law, common law, and custom, and the king's proclamation, i.e. anything created by the royal prerogative is not a source of law. So basically, Parliament creates acts of Parliament, and in the first promise, those acts of Parliament are the instruments that are used for Parliament to control governance, the executive only. They cannot tell the royal prerogative how to run the courts, the independent judiciary.
Mm.
The royal prerogative has two powers under it, which are not parliamentary. The executive and the independent judiciary, and the independent judiciary has been reaffirmed in 2005 under the Constitutional Reform Act that it must be independent.
Yeah.
So that there's all been set out from the Bill of Rights. Now, both Parliament and the executive and the judiciary are under an obligation under Article 3 that the courts are not ecclesiastical, under 5 that there are no commitments or prosecutions resulting from anybody petitioning the monarch. Article 10 that no excessive bail fines can be enforced, or nor cruel or unusual punishments inflicted. Article 12 grants that affirms that no grants and promises of fines and forfeitures before conviction by jury. In Article 11, and if any are made, they're null and void. All of them, legislative, executive, and judiciary, are bound by these. Beyond that, it's the royal prerogative under the second promise, which creates the independent judiciary, which has been reaffirmed, like I said, with the Constitutional Reform Act 2005. Now, Parliaments and statutes is detailed in Article 13. The reason for Parliament to meet frequently under Article 8 of the Bill of Rights is that you can take your grievance, any grievance that people have, or any single person on the land under their jurisdiction has, go to your MP, complain to your MP. Your MP's job is to go to Parliament and get remedy or redress for your grievance. And to do that, Article 13 is clear. It says they can amend, strengthen, or preserve the law. Okay, so they are subject to the law, and that is all they can do with the law, nothing else.
Mm.
Okay, so that there is sort of the history, and those governing today are still subject to the Bill of Rights, and that there is the source of their authority. They are creatures of statute, because it's the Act 1 of William and Mary and the Bill of Rights and the Coronation Oath Act that creates these fictions of law.
Yeah.
Okay? Without those authorities, they do not exist and have no legislative or legal authority to govern. And
Yeah.
of.
They are bound.
Change them.
Yeah.
they have bound their successors.
Yeah.
Now, there's no other rational way that you can uphold the constitutional principles of the rule of law and the separation of powers. All of them are subject to the rule of law, and the rule of law is we vote for MPs once every few years. That and so you have what they call the political constitution is what they're trying to push. Oh, you have the right to vote and you can vote them out next time if they don't do a good job.
Yeah.
That's no bloody good. If after they get into power, they create a grievance for you.
Yes.
What, you've got to wait 5 years to get remedy?
Yeah, nonsense.
That is why you have the two routes. Okay. In the judiciary, under Article 5, you can petition the monarch through the courts to get remedy without having to wait until the next elections. So it's very, very simple and clear. And we know again that legislation is not law. So statutory acts of parliament and statutes are not law by going to understanding legislation, where in the subsection it says in case law, this is how acts of parliament are interpreted by the courts, i.e., parliament does not create law. Law is created in the courts, where individuals will argue a case, whether it's what does the act of parliament mean, being the expressed cumulative mind in a single document of the legislative body, and under the common law, that includes to ensure that it's lawful, and that is not what the courts are doing. And that's where our problem is. There is no independent judiciary. It is giving acts of parliament the force of law through the orders it makes. It's the court orders which creates the binding law and is enforceable. It's not an act of parliament that's enforceable.
No.
So, and that it all derives from royal prerogative, okay, is very clear, because it's no different from you or me. Sorry, the interpretation is no different from you or me under our divine rights to enter contract. If there's a dispute, it also needs to be interpreted, and that interpretation by the courts includes whether the agreement is lawful or not.
Yeah.
That everything stems from royal prerogative. We've just seen last year King Charles' coronation, and this is not what do they call it, acting or whatever, custom, or you know, like a play, like theatre.
Yeah.
This is lawful. This is the binding. My words are my bond. Okay. And to confirm that everything's subject to law, the act of parliament can be nothing more than a claim, because it's by proclamation under another word, a different color of law called enactment, that the monarch creates. Without the monarch, there can be no acts of parliament.
Right.
The monarch is still the source of power. Without the monarchy, there is nothing. So the monarch needs to open parliament. So even if they're elected MPs, they can do nothing until the opening of parliament. No business, no bills, no nothing, no anything. And the acts of parliament say, be it enacted by the monarch, His Most Excellent Majesty, by and with the advice and consent, i.e., a meeting of the minds of the Lords Spiritual and Temporal and Commons, the two houses of Parliament, in this present Parliament assembled, and by authority of the same. And the authority comes from Act 1 of William and Mary and the Bill of Rights and Coronation Oath Act. So there can be no dispute about how this works. This is all what are called primary sources of evidence. There's loads of theories going around about Dyce's theory about Parliament being supreme lawmaker. That's not actually what is said. It's been selectively taken out to push this thing about parliamentary sovereignty, and you'll hear the courts always saying, "Oh, we can't judge this matter because it's oh no, that's parliamentary sovereignty, and we can't tread in their house, and that would be abuse of the separation of the powers." The court needs to understand not only is Parliament subject to the rule of law, the executive is subject to the rule of law, but also the courts are subject to the rule of law. The rule of law is sovereign and the Constitution. It's not Parliament.
No.
So, what I want to do is just go through the latent judgment, because in this video I just want to continue then talking about the liability order, because there's a lot more in the latent judgment which will take way too long. So if we start with the latent Bristow judgment. Now, essentially, I'm just want to talk about the liability order stuff. And so going through at 7, in many ways, the term order is a misnomer if used in the same way as might be understood in civil courts of England and Wales, i.e. there's a distinction between an order made in the magistrate's court because it's not in the same format as created in the civil courts, okay? So, and the judge is quite right there, and we'll go through and look at that in more detail.
Just increase the size of the page, Mark, just for...
Okay.
Yeah, perfect. That's good.
Order as such is ever actually produced in the by the court, meaning the magistrate's courts. We need to distinguish between these two. And what is ordinarily thought of as a valid order of the court, and what the magistrate's court produce is the issue, i.e. when and what is a liability order.
Yeah.
Okay. In this proceedings, what Leighton presented was there is no paper record. Okay. And therefore the court should not be satisfied that such a liability order was ever made against him.
Right.
That was his argument, and we'll come back to it on the reasoning.
Yeah.
Okay. The judge then points out that the particular method by which liability orders produced means that there is no record retained by the court regarding the same. This is actually incorrect. But this is basically what Leighton is arguing. So he's summarizing Leighton's arguments here again. And he's saying that that's in breach of Article 6 of the Convention of Human Rights. Then, so that's what, in essence, Leighton argued. And the issue is all about the liability order, whether it is or isn't a liability order. And then he continues with the evidence which was brought before him, was that the enforcement agents simply received a list of persons against whom liability orders have been obtained. Now, at this point, this should be allegedly. Okay.
Yeah.
And the defendants, on the evidence, taken them at their word and proceeding accordingly, i.e. the enforcement agents just accepted it as gospel.
Yeah.
Got on with it.
Nod and a wink, Mark. Yeah.
Just without question, just order following.
Yeah.
Okay?
Yeah.
So then it continues that they recognize that this document, so as the case continued, they accepted it was no longer in dispute that this document could not be read as providing authority to do what the letter says. Merely as written confirmation of instructions to the defendant to act on behalf of the counsel. So so we go then onto the Court and Tribunal Enforcement Act, paragraph 66 of Schedule 12. As a debtor, you can get remedy if they're in breach of a duty. Okay, a breach of a duty which causes you harm allows you to bring a common law tort, i.e. a civil action.
Mhm.
Okay. Now, this paragraph applies to when an enforcement agent breaches a provision of the schedule or acts under enforcement powers under a writ, warrant, liability order, or other instrument that is defective. That breach or defect does not make enforcement agent of a person he is acting for a trespasser. Okay. Now, so what they're saying is, if they have a reasonable belief that they're acting lawfully, then they cannot be trespassers. And this is why, if you put up this denied implied rights of access and trespassers be warned and all of this, if they have a reasonable belief, and that's why Leighton wasn't awarded further damages under the Harassment Act, because he couldn't establish that point.
Right.
Okay. Then this here is what the crunch is, subparagraphs 6 and 7 and 8. Okay. If reasonable belief, which is what I was just saying. Okay. So you need to be successful in a tort like Leighton was, you need to prove that they actually did not have reasonable belief.
Right. Okay.
Okay.
Yeah.
And that therefore is a breach of duty. So first thing was that it needs to determine whether liabilities were actually made by the magistrates. So what he said was the evidence before me was the copies in the trial bundle, and pairing that with the signature applied at the end of the list by the magistrate or district judge. So that was the evidence that he had. Leighton didn't have any counter evidence. The document, as I say, do reveal a series of problems with the process, and he pointed that out because this is not a format which the civil courts are used to.
Yeah.
Okay. And so this is why it's important, because basically, as we'll see later, with enforcement, this same point applies to any enforcement, be it attachment of earnings, deduction from social benefits, imprisonment, any of those, or sending the bailiffs around. It applies to everything.
Okay.
Issue. Okay. What he's saying is, and this is based on, in the High Court, you have the name of the person who made the order. And all that they've done, really, on that single piece of paper at the end of the list, okay, is certified a number of liability orders made that day. So the question is, was mine one of those made on the day? Okay. So because of the evidence, basically, he prefers the evidence set out in the documents submitted by the defendant. Therefore, he's satisfied a liability order was made on the balance of probabilities.
Right.
Okay. And then the council noted in their submissions passed that information, i.e. they didn't pass evidence of the liability order, just their claim that liability orders were made. Okay. So this year, putting oneself in the defendant's position, they were being told by a public body, i.e. order following. However, and for the purposes of Section 66(8)(b), that would amount to grounds of a reasonable belief. Okay. So what he's saying is, with the facts, yes, I prefer the evidence that they had a reasonable belief. Okay. However, it was not, in my judgment, necessary in order for the enforcement agent to have a reasonable belief for him to go further and inquire to how the order was attained in the process. So this goes to what actually did Leighton do to get them to question the validity of the liability order.
Right.
Right. And so specifically, Leighton then went on to paragraph 26. The enforcement agent must, on request, show the debtor and any person who appears to him to be in charge of the premises evidence of his identity and his authority to enter the premises. Okay. And this can be done there, or as we've been encouraging people to do, ask for this authority in advance when you get the notice of enforcement from an enforcement agent. Engage early. Okay. So it goes through then what it in relating, it discusses basically that part. So what the defendant argued, I don't have to give it in advance, I can give it at the time when I come. And the judge disagrees with that. He says, exactly what we're doing, you can ask for it in advance. Okay. And this is important here. It's not, in my judgment, sufficient simply to signpost him to the local authority. Remember, it's the enforcement agent that must prove their authority when they're at your door. They can't tell you, oh, just go and look, go to the council, all right? Or go.
Well, that's what they've been saying. They just go and see the council.
Correct.
Yeah.
Okay. So this here makes it clear that if they cannot prove the authority at your doorstep, they must immediately leave. Okay. And so this is why Leighton won, because when the guy came, he'd asked for that authority and the enforcement agent could not provide it.
Right.
Okay. And that is why they no longer had a reasonable belief. Okay. So fine, in the beginning, they had a reasonable belief and the judge accepted it. However, once they were put with the knowledge, i.e. notice one, okay, that reasonable belief is no longer a reasonable belief and you need to follow your due diligence.
Yeah.
Okay. Now, having done, that's all I want to talk about today on this. Okay. It continues to go on through the Protection of Harassment Act, which we'll do a separate video on, and that'll be a short one. But here is interesting. Okay. The Statute of Marlborough 1267 is included in this judgment because that was something that was brought up in the case. We don't use 1267, we use Magna Carta, and confirmation of the Charters 1297, so that's 30 years after this. Then the Bill of Rights, Act 1 of William and Mary, Coronation Oath Act, all afterwards. But this shows you that it needs to be addressed. This is a reasoned judgment, okay? So another argument that Leighton did was about commercial liens, a separate thing. And that there addresses the issue of what people call implied contracts, which is a misnomer. And the judge, in conclusion, is satisfied of the breach. Having established the breach, is entitled to remedy. Okay, and then it goes through with the case law for working out the remedy and what the judge granted him. And he's explained here why he was not awarded exemplary damages. Again, that'll be part of a separate video.
Excellent.
So what I want to do now then is, because the issue is what is a liability order?
Yes.
Okay, that's what it's really about.
That's what it's all about.
If we start off with the Local Government Finance Act. So let me share the screen. And here you will see how the rule of law prevails over acts of parliament. You'll see it in action here. So if we start Schedule 4, let's make Schedule 4 duplicates. Got it. Schedule 4. Okay. And then we scroll down to liability orders. This section here. I'll try and make it a bit bigger as well. And let me move this over. Okay. No, I can make that even bigger. Let me just see if it'll fit on the screen. Okay, a little bit smaller. Okay, so this is the section we're talking about, liability orders. Okay, so for enforcement, this section is about enforcement. The authority, and it says regulations, i.e. delegated authority. So Parliament is saying, you can do this. And you can make regulations and fill in the detail as to the authority applying to a magistrate's court for a liability order against a person whose sum has become payable. And the magistrates shall make the liability order if it is satisfied. It has become payable and has not been paid. Then the regulations again may include a provision that the order shall be made in respect of the aggregate, okay, of the sum payable and the sum payable for costs incurred in obtaining the order. Okay, so that is all that the regulations, this is all they're authorized to make for that. So hopefully people can see this is primary legislation. This is an act of Parliament, the Local Government Finance Act. So this here is Parliament delegating authority to make secondary legislation or regulations. Okay. So if we go to those regulations to see if Parliament acted within it. So basically, the executive has delegated authority to make regulations as it sees fit, that the magistrate's court shall make an order if it is satisfied the sum has become payable for the aggregate of the sum payable and only costs incurred in obtaining the order. Anything else, they have no authority to make any regulations. So if we then go to hang on, still in here, okay, in Schedule 4, it goes through the enforcement regulations as well. So that in regards attachment of earnings, what regulations can be made. And that then in summary is an attachment of earnings can only be made after a report from an enforcement agent. Okay, so if we look here at 1A, okay, here at B, okay, an attachment of earnings can only be done where a person authorized to act under the section of, the enforcement agent. And here's the crunch, the limitation. Okay, so the enforcement agent must report to the council that they were unable to find sufficient goods. Without that report, there can be no attachment of earnings made. So that there is something that we need to make sure.
Right.
The power to make deductions from income support, that they can do without any further investigation. A warrant for committal. Okay. Firstly, it's for a maximum of 3 months, 81F. Okay. Which shall not exceed 3 months. So it doesn't matter how much you owe, you can only go to jail for a maximum of 3 months. Okay. And that stops all enforcement on that liability order. So if you've got a £10,000 or £15,000, whatever you owe, the maximum is 3 months, and that gets rid of all of that debt. But again, okay, here, and there's the requirement that there are insufficient goods to satisfy the amount. So again, a report is needed from the bailiff or enforcement agent saying, well, we try to get stuff out of them, but they don't have enough stuff for us to steal. Bankruptcy order is this bankruptcy. No,
Just below that.
Hmm?
There it is. Yeah.
Okay. So what they're saying here is there's no requirement of enforcement agents in this. And in the liability order itself, okay, is to be taken for the purposes of insolvency, the grounds of petition as it. But again, that there needs to be evidence that the liability order exists, coming back to the same problem. It applies to all of these things here. And in the Insolvency Act, this can only be done if it exceeds £5,000. And the charging order, okay, oops, have I missed the charging order?
Yeah, it's just above.
Okay, here.
There it
Okay,
is.
so the charging orders, I can't find any relevant amounts. Okay, but this here is really the same thing. The order, the liability order is deemed evidence of the debt. And sorry, here in B, okay, it'll be enforceable as an equitable charge. Okay, and this is where the authority comes to make it into an equitable charge. Right, so that is the authority from that. So now we need to see what actually is going on. Are there any abuses of power going on here in the regulations?
That's a laugh.
So if we start duplicate. Okay, so we start at section 17. Okay. Right. Bum, bum, bum. 17. A demand notice. Okay, this is the definition. So a demand, come on. A demand notice is required to be served by regulation 18.1. So the word is a demand notice. Nothing else no other wording is authorized anyway. So if we next go then to section 18, they actually have changed legislation.gov. They've actually put this here now into secondary legislation, and it tells you what has not been applied. So this stuff in the bottom here is not up to date, and you need it. You can check here now. So if we go down here, 18.2 has been amended, okay, by that statutory instrument, and that I've got that one open. Amendment 1992, and section 18, what's been amended here? Hang on, let's go back there. Open link in new tab. Okay, opening options, open whole thing. Latest. Okay, they haven't got the latest in here. So regulation 18 here. Okay. So in regulation 18, demand notices for the words and preceding financial year to the end of the paragraph there is substituted, and any preceding financial year. So, oops, which section was that? 18.2, paragraph 1. So, in essence, they've made changes there. But a demand notice does not only have to be for one financial year, it can be for any number of financial years. Again, demand notices, the requirement for demand notices, the wording is demand notices. Okay, and then at 19, provision 19, it must be at least 14 days before the first installment is due. At 23, 23. Then if you don't pay the installments, okay, under section 23, if you don't pay within 7 days, sorry, if you're late on an installment, they must send you a reminder notice. Okay, that reminder notice gives you a further 7 days. And if you don't pay, the full balance becomes payable. All right. So it's giving you notice that if you don't pay your installment within 7 days, automatically the full amount becomes payable. That's what this notice is telling you. Okay. Then the next one is section 33. Okay. Now, this one is not being done by the councils. Okay. So let's just look at what it says. So subject to subparagraph 3, okay, before a billing authority applies for a liability order, it shall serve on a person against whom the application is made a notice called a final notice, okay, which is in addition to any notices required under part 5, which is the section 23 notice, and which is to state every amount in respect of which the authority is to make the application. So a final notice may be served in respect of an amount at any time after it has become due. And this is where the councils are trying to shortcut, so to speak. A final notice need not to be served to a person who has been served under regulation 23.1 with a reminder notice, and here's the important words, in respect of the amount concerned. They've given you an installment notice not a full balance notice.
Right.
Okay.
Yeah.
Now, if we look then at this one, okay, and so this is another judgment. So the councils have interpreted that as we have already provided you with a section 23 notice, therefore, for an installment, and on there we've said that the full amount will become payable if you don't pay within 7 days. Okay. Whereas Regulation 33 says that whatever amount you're claiming with the court, you need a final notice for that amount. And that's confirmed here in section 12 of the Wilcock case.
Oh.
Again, High Court that says if the taxpayer fails to pay that sum and does not respond to a final notice served under Regulation 33, then the authority can seek a liability order. Okay, so if the councils have not sent a Regulation 33 final notice, okay, for the amount that they want to take you to court for, then they're in breach of the regulations, and any order made by the magistrate's court is void.
Right. Okay.
Okay, and this is something that the councils have not been doing. So that there shows you how this section here was created by the executive, okay, under authority from the Local Government Finance Act. So it has legal authority or statutory authority. But this section here takes away the argument the councils have been using for making applications to the court for the final amount, as the court has confirmed. So the court has interpreted this section, i.e. in accordance with understanding legislation, and the court order, the court's reasoning and rationale, that is what prevails now over this piece of legislation, affirming legislation is not law, but that the court is where the law is created. Okay. So then that was section 33, right? Then at section 34, the application to the liability order for the liability order. Okay, and in section 2, okay, what does that say? The application is to be instituted by making complaint to a justice of the peace. Okay, so for requesting the issue of a summons. So the regulations even say that the summons must be authorized by a justice of the peace.
Not a legal advisor.
Not a legal advisor.
No.
Okay, but we've already covered that in the video that there is no authority for anyone other than a justice of the peace to issue a summons.
Mm.
Right, then under further provisions, okay, again, the updates, what the updates do is delete this sentence or that part of it and that part of it. Okay, so as if those two parts are not there. So if we read it from the beginning, a single liability order may deal with one person and one such amount or aggregate amount as mentioned in 34(7), i.e. the amount payable plus the costs. Okay, so this doesn't exist anymore. Or if the court feels fit and the blue part doesn't exist anymore, may deal with more than one person and more than one such amount, i.e. you can have a bulk listing.
Yeah.
The bulk listing.
Yeah.
Okay. The summons needs to be issued, and then down to part 3. Okay. now what this means here, by removing this, okay, and this does not remove the requirement not to have a format for an order.
Right.
Now, the intent of Parliament was, and the intent of the executive was,
incoming voice call from
that there's a liability order. Okay, so it does not remove it, and this is essentially what the argument in Leighton's about. Okay, what is a liability order? All right, so that there, and then in section 3, okay, the amount in respect of a liability order is made enforceable in accordance with this part, i.e., once you have a liability order, you use these provisions, the enforcement provisions of the Council Tax and Enforcement Regulations, Part 6, which is enforcement. And hence, in 35, it is not to be treated as a sum adjudged paid by the court for the purposes of any of the provisions of Part 3 of the Magistrates' Court Act, satisfaction and enforcement, i.e., a liability order that is not enforceable under the Magistrates' Court Act, but it's enforceable under these provisions. Okay. And then it goes on with the attachment of earnings and all of that stuff. All right. So it does not remove the obligation to make a liability order. And so the question with Leighton is, what basically does it mean to make a liability order? What constitutes a liability order? So if we go then to the Magistrates' Court rules and see what if that can help or assist with that question. Okay, so in the Magistrates' Court rules, if we go down to section 16, oops, here, section 16, let me make it bigger so people can see. Am I still sharing the screen?
Yeah.
Okay. So in section 16 of the Magistrate Court's rules, it says a record of adjudication, a record of a summary conviction or order made on complaint required for an appeal or other legal purposes may be in the form of a certified extract from the court register.
Yeah.
So this is telling us for legal purposes, and we're talking about legal purposes for the enforcement agents, for attachment of earnings, for charging orders, for committing people to prison. This is the only record of the order of the court having been made. Okay.
The gold standard.
The gold standard. And
Yeah.
if we go down to section 66, and those people that are familiar with our work, this is well covered in there.
Yeah.
It's 66, register of convictions, etc. Okay, shall keep every magistrate's court shall keep a register, a minute of memorandum of every adjudication, i.e., a liability order being made. Okay, and that there may be electronic or computer system, but it must include the name of the informant or complainant, the name, if the date of birth is known, of the respondent, the nature of the complaint, the date of the complaint, whether there was a consent order between the parties, and a minute of the adjudication.
Right.
Court must keep this, and this is why with the FOIs it says it's not sufficient to speak the order, there must be a record of the order, and we've covered that again, and that's for the obvious reason that a spoken order, only those people that were present can give first-hand testimony of its existence. but it's the written record. So if the bailiffs came around and said, oh yeah, so-and-so said there's an order, and that's exactly what happened in Leighton, the council said there's an order, that's hearsay evidence, that is not sufficient to enforce. And then the alternative is to that is that there's the memorandum of entry, and then in section 68, it's got the certified extract of the court register. Okay, proof of proceedings, the register of the magistrates court, i.e. the memorandum of entry, as they call that, or an extract from the register certified by the designated officer shall be admissible in any legal proceedings as evidence that the court entered into the register. Okay, so this here is what we've been pushing for the last, since we've done the knock-knock challenge, and that they resulted in the updated procedure for liability order applications, not only from the Justices Clerk Society. I can't find my copy of the Her Majesty's Courts and Tribunal one, but they've also confirmed this and updated their procedures. Section 4. Okay. So let's just go here. Start at section 3. Oops. Okay. The court hears the bulk application for all non-attenders, i.e. that there basically means that if you do not attend to court, it's dealt with as a bulk application. And the council needs to prove under oath with evidence for that. Any defendant attending or writing to the court is dealt with individually, and orders made or not made in their case. Their attendance or otherwise is also recorded. Okay, so if you do attend, there will be a individual record of your attendance. That there, the legal advisor will record the overall number of liability orders made, withdrawn, dismissed, and adjourned. Where the court does not make an order set out in the council's printout, the legal advisor notes the actual order made against the defendant's name in the printout. Okay, so that there, this section here requires that printout to have a note against your name. Okay, that there is the court's record of all orders made. That there should be entered into the Libra, the court register. Any adjourned cases are individually entered, i.e. if you get an adjournment, you will get a new summon, adjournment with the new dates. And the council's printout marked up by the legal advisor is kept permanently as an annex to the court register. Okay. And that there is where the court, or how the court makes the liability order. So it goes on to say here under section 4, right, the order is made when the presiding judge pronounces it. However, it has the word "and" after that. Come on. Okay. And means this is an additional condition for an order to be made, is recorded in the court register, which we've just gone through. Okay. Since repeal of the prescribed order, there's been no court produced order. Actually, that there was suffering the same problems of what we're talking about now. So I'm guessing people already challenged this liability order thing pre-2003, where they thought they'd just fudge it over.
Mm.
Okay. Now, it says the council's software will generate the notice. Remember, notice is only a notice putting you with knowledge. Whether it's true or not, the claimant must prove. And the notice should not be signed or endorsed with the name of the JP or court officer, still less a justice's clerk. Okay. Now, that is because this is a council document. It's got nothing to do with the court, and therefore they cannot use the court's officers' names.
Well, someone is basically saying the council software generates a notice, and that's perfectly reasonable to prove that there's a liability order.
No.
That's what he's saying.
This is what the Leighton judgment is saying. That is not
sufficient.
Yeah. Okay. Nor is it sufficient for somebody to come to your door and say, somebody told me. Okay?
Yeah.
Right.
Of course.
Okay. However, to fix this problem is really quite simple. I imagine it's quite simple. Okay. In that, simply, the justice of the peace may authorize the use of their and get somebody else to put their name on the document. So, so long as the court keeps a record of that document, that's fine. Nothing wrong with that. But we can make automated bank transfers for our employees, for instance. Surely it would be simple enough just to make a link from the council software to provide the data to be uploaded on the court's register. And that way, the court could keep a copy of the liability order made, which is sent out by the council, which is fine, because it's about the judicial decision being made by the court, not who posts it.
Mm.
So this issue really could be solved relatively easy, either by creating a link to the linking the council software to the created data base, which can be imported into the court's register. Or alternatively, they've got on individual cases, you already get individual memorandums of entry, and on bulk listings, they can do that by certified extract. However, what's missing with those is that on the certified extract requires the magistrate's signature next to your name to confirm that that was the individual order that was made. So they can send you that page of the list which the court retains. So it's not difficult to overcome this problem. However, what we've been doing is we've been chasing the courts for liability orders, and what the Leighton judgment makes absolutely clear. Don't waste our time. We shouldn't be paying for liability orders. Let the council do that.
Yeah.
The council should have the evidence to give to the enforcement agents. And that's how simple the problem is.
Well, everyone's just going, go and see them, go and see them, go and see them, pointing the finger.
And the reason is, again, because it's the lag between the change having been created as a result of pressure we've put on with FRIs, others have put on. The cumulative pressure that's been put on has resulted in this matter having to be addressed. And basically, anybody now that can evidence that they've noticed the enforcement agents can now not only sue the enforcement agents under the Leighton judgment, but they also can sue for the actual council tax that they screwed out of you.
Oh, really?
Yeah. because they failed to prove their authority,
Right.
and that's what the notices do.
Right.
And basically, with the notices, with the 3 notices, if you followed the procedure, you will have met the requirements, not only for the liability order and the damages which Leighton got, you will also be able to get further damages for the protection of harassment under the Protection of Harassment Act, and you'll be able to get exemplary damages.
Right.
So anybody that's followed the process, basically using this precedent of the High Court now, can not only get their council tax back for that period, but they can get damages, sue for harassment as well, get damages for harassment as well as exemplary damages. And we'll be starting to do this because that's what's going to create the change.
Yeah, certainly.
And then on another side, the breach of the duty of the court's officers, that means the magistrates and the legal advisors, by them breaching their duty by not allowing us to speak, not allowing us to cross-examine the evidence, and not giving us reasoned arguments, we can sue them as well for breach of duty in the civil courts.
Right.
So this judgment is massive.
Yeah, yeah, huge. Huge.
Sorry that's so long, but I think it's been, there's been a lot that is covered in it. And there's more to come. Watch this space.
Yeah, totally, totally. 2024. Well, every year for the last 2-3 years, there's little progresses and changes going along.
But you can see already with people focusing on the true problems. There's no mention about freemen of the land. There's no mention about, I'm not subject to your law, who are you, all of this sort of nonsense. There's nothing in here about, oh, I'm not the legal fiction, here's my birth certificate. There's nothing in here about the definition of the word person. There's nothing about corporations, none of that nonsense.
No.
Okay? So using simple rational English, which is the basics of interpretation, okay, this here's proof that all of that is a waste of energy.
Absolutely.
Okay.
Absolutely.
By focusing and understanding the problem and what is right and wrong, and here what is wrong is quite simply, when asked for authority, the enforcement agent failed to be able to evidence that and continued enforcing instead of retreating under his obligation to keep the peace because he failed to prove his claim.
Yeah.
Simple stuff.
Yeah.
Okay. So hopefully people will stop wasting energy on person and corporate.
Oh no, it's never going to happen.
Number and all of this stuff.
It's never going to happen.
Here's your proof. You know what you're doing.
Never going to happen.
You can do it.
Yeah.
And that's what creates the change.
Yeah.
So
anyway, look, it's everybody's choice. If you want to go down that route,
if people need to
just don't involve
keep
us.
on bashing their head.
Yeah.
Before they start to question their beliefs, that's what's needed.
Yeah. Totally.
But here's the proof that if you understand the rules, which are very, very simple, it doesn't take rocket scientists. You don't have to learn a new language. You don't have to learn a new way of writing, 2 dots and little letters and, all of this nonsense. None of that's got any evidence of working. Here's the proof that it's irrelevant. It's got nothing to do with it because Leighton got awarded £4,000 damages.
If there was any evidence, Mark, it would have been produced by now. We'd be using it in the courts and we'd be making serious change.
Absolutely.
So
but now,
honestly,
with this, hopefully people see that there is remedy there if you know what you're doing.
Yeah, definitely.
If you follow the evidence.
100%.
And this year, there's going to be a lot more of these.
You know that.
and this year, there'll be civil actions in tort for magistrates and legal advisors breaching their duty. The legal advisor's duty is to the rule of law, to the court, and they have an obligation to put the court with all relevant law. If
Yeah.
they do not do those three things, they are misadvising the magistrates, and therefore the legal advisors are in breach of their duty, and ignorance of the law is no excuse. The magistrates, under the rules of the court, must allow the evidence to be produced, to be cross-examined. They must allow us to present our arguments, and then they must provide a reasoned decision. 3 breaches there of duty, which means we can sue them for damages.
Yeah.
If we've put them with the knowledge, okay, the notices, then we can get exemplary damages as well. We
So,
will force this change. If they
Yeah.
don't do their jobs properly, it's going to start costing them in their pockets.
yeah, one way or the other. That's the only way, I think, Mark.
And once we've won the civil cases, then the civil cases can be brought, that there's the prima facie evidence of misconduct in public office. So once the civil case is won, then we can move into criminal prosecutions with them.
Music to my ears.
So this year is going to be massive.
Nice one.
Welcome to 2024, the year of full exposure.
Hopefully. All right, mate.
Well, and more people are getting it, Brian.
Yeah, of course. Yeah, of course. Absolutely.
It's not the exposure, you know, there'll be 2, 3, 4 more latent cases, a dozen, might be 100, who knows?
Yeah.
We only need 2 more to create the new reality. This here's the fact. The next one's witness 1, and the third one is witness 2. That's your new reality.
That's it.
So then it's just a matter of time for them to topple down.
Brilliant.
Do your jobs properly. That's all we want.
Well, thanks very much again, Mark. There's a hell of a lot of work that goes into all of this. You know, by yourself and others, you know, it's not a 5-minute process.
Well, there's loads of, we've got over a dozen people now that are starting to articulate this really well.
Yeah, it's fantastic.
And we've been at it 2 years. So if each of that, if we have a repetition based on that, in another 2 years, we're going to be over 100 people.
Mm.
And in another 2 years, over 1,000 people. That's way more than we need to change the whole system.
Absolutely. Nice one.
Focus the light bulb without a lampshade and focus it in to the truth, so that it's like a laser then. That's
absolutely. Focus in.
Brilliant, Brian. Thanks.
Cheers, mate.
Okay, take care. Have a good day.